Last class period we were talking about HIPAA and certain privacy rights. Let's move on and talk about a couple of areas. I think we can combine a couple in terms of restrictive covenants and intellectual property. And let's start with this idea of restrictive covenants. What is a, well, let's back up. Tom, we started with you earlier tonight, so let me pick on you. You mentioned trade secrets when we first started talking about privacy, or whenever that was that we did that. What is privacy? What is a trade secret?
A trade secret is basically a way you manufacture something or produce something that may give you an edge over your competitor.
Okay, yeah. A trade secret is something that may give you an edge over your competitor. And whether it was last week or whenever it was that we talked about it, I think you mentioned Kentucky Fried Chicken and Popeyes.
Yeah.
Okay, and yeah, we don't want Colonel Sanders' 23 secret ingredients getting over to Popeyes. And so companies have a need to protect their secrets, because let's take that KFC example, Tom. If Popeyes then knew what KFC's secret special recipe was, how would that hurt KFC?
Their competitor would be able to produce the same chicken they had, so they'd lose their flavor edge.
Yeah, they lose that special edge that they have, okay? So there's a need to protect what we call trade secrets. Now, how do we protect trade secrets? How does that come into play? We're talking about employment law. We're talking about employer-employee situations. What's out there? Huh?
Non-disclosure.
Okay. Non-disclosure is one way we can protect it. You can have your employees, well, let me ask you, what is a non-disclosure agreement?
An agreement, basically, you won't work for a certain type of company within a certain radius of the company that you're working for now. So if you work for a newspaper, you can't work and you sign a non-disclosure agreement that says you can't work for another newspaper within this 50-mile radius. You literally can't unless you get consent.
Okay, real close. I'm going to tweak a little bit.
Okay.
What you've just mentioned is actually a non-competition agreement, all right? And frequently they're together.
Yeah.
Most of the time they are together. But I don't necessarily have to sign a non-competition agreement to have a non-disclosure agreement. You agree?
Yes.
And why is that? So now tell me what a non-disclosure agreement is.
An agreement not to tell or give out anything that you learned from the company.
Yeah, that's exactly. Tom says a non-disclosure agreement, and one way to protect secrets, trade secrets, is through a non-disclosure agreement. And a non-disclosure agreement says, hey, I'm not going to share the information that I have. Okay, we've been talking about Colonel Sanders. I'm not going to take the recipe that I make every day and share that with anybody else. All right, that's a non-disclosure. All right, we've also talked, and Tom also gave us a non-competition agreement. And a non-competition agreement, just to paraphrase or summarize what Tom said, is this idea that if I work for company ABC, I won't leave, or upon my leaving of ABC, I won't go and work for XYZ. Okay? And as Tom pointed out, generally similar industry and generally some kind of boundary or area. All right? We call those a restrictive covenant. So we have non-disclosure agreements. We have covenants not to compete. A third way that employers try to protect their trade secrets and information or their assets is what we call a non-solicitation agreement. Okay? Those aren't as common or not referred to as common. But what is a non-solicitation agreement? Anybody got an idea? Jackie, you want?
Is that the one where you won't, after leaving a company, you won't try to go get those clients that you formerly had?
Nah, that's still you were real close.
Okay, you leave the company and then, like, say you start your own company, you won't try to, like, take people from your former.
There you go. There you go. The non-covenant, the covenant not to compete, is the one where I won't take your clients. Okay. The non-solicitation is, and could be clients as well, but generally in the legal field, it's I won't take your employees. All right. And why may a company not want its employees taken?
Well, it's like if you're one of the best and brightest in your company and you're like, hey, I can go do this by myself, you're going to look for other people that you may optional.
Right.
And so it's like you're just taking the brains of their operation.
Taking the brains, I'm leaving the rest of it away. You know, I don't care about the rest of the morons there or whatever, for lack of a better term. All right. And then I'm going to have a great company, and guess what's going to happen to the former employee or the former employer? They're going to go down the tubes. All right. So that's why we have these agreements, and really that's the nature of them. Okay. Now, a couple of things. What do you think about them? Let's talk about that. We try to talk about whether it's a good idea, bad idea, and this is your opinion. This isn't necessarily what's right or wrong. But are these covenants not to compete? And let's loop everything, so we're not saying all three agreements at the same time. Let's loop them all together, and frequently they are. Are these covenants not to compete? Should employers be allowed to have their employees sign these covenants not to compete?
Well, I know one example that it hurt us is our insurance agent, our business insurance agent, left his agency and went to another one, and then we weren't able to use him. We weren't able to be clients of his, and it wasn't our fault or our choice for him to leave. We should have had the choice to be able to continue to use him, but he wasn't able to use us, have us as a client because of that. Regardless of if he solicited us or not, we didn't.
Okay.
We just want to go ahead.
Your argument is, hey, it shouldn't be allowed because it affects, and if I'm paraphrasing this all wrong, Whitney, tell me. But your argument, as I understand it, is they shouldn't be allowed because it affects innocent third parties.
Right.
Okay? And as a third party, I should be able to do business with whoever the heck I want to do business, and I shouldn't have two other people telling me who I can do it with.
Right, as long as he doesn't. Now I understand, like, if he would have been like, hey, talking bad about his former employer and saying, you guys, you need to come to us and I'll give you a deal if you come to me, that's wrong.
Okay.
But if I, on my own accord, make the decision to go with him because I want to do business with him, I should be able to.
Okay. Somebody take the position, no, I understand what Whitney's saying, but covenants not to compete are still important, despite what she's saying, or even an argument to what she says. John.
I think to a degree, like clients and other people who you build a network out of, that especially if you work for like an agency or another company, that network of clients is built through the company's resources, and they've done the work in acquiring those lists of clients. And so allowing someone to branch off and take a bunch of the clients that the company's resources were used to gather, it doesn't really make sense that they should be able to do that.
Even if they're not the ones who are soliciting it.
Yeah.
Because here's what happens. As a practical matter, and I truly understand what you're saying, Whitney, as a practical matter, what's going to happen? And I will tell you, since I've left private practice, I've had a lot of people call me up. And interesting, just side note, lawyers, covenants not to compete with lawyers and law firms are illegal and void against public policy. It's the only one in the state of Missouri. In other words, doctors can still have covenants not to compete. It makes no sense to me whatsoever. But as a lawyer, if I had a non-competition agreement with my former firm, it would be invalid. Huh? Null and void. Okay? But having said that, what happens? It's not so. What happens is somebody will call me up and, they'll say, hey, where's Greg? Or where's John? Okay? Or where's Insurance Man? And they'll go, well, he's left. All right? Then they start digging around because that's who they want to do business with. So whether the argument on the flip-flop is whether you solicit or not, as John says, company built the resources, okay, that solicitation often comes in through exactly what you say. Now, and I agree wholeheartedly. That's a very good reason why you should not have covenants not to compete, but that's the flip-flop. Other reasons you shouldn't have or should have covenants not to compete. Other arguments for them. Jackie.
And I feel like it's a pretty valid business concern, especially if, say for example, you are in the tech industry. That one is so fast-paced, and the advantages in the patent that you may have or the knowledge that you may have, someone can pretty easily be like, oh, I'm just going to turn around and start my own company, and you've lost a lot of resources.
You've lost a lot of resources, okay? And I think that's really the key, is resources and trade secrets. But the idea is you put a lot of people into training. Now, the flip-flop is, well, this person already had that knowledge or whatever, and you can argue that. but still, it's to protect the resources, and there are a lot of resources that need protection. Other reasons for or against, John?
I think it's interesting that in a capitalist society that we would set up laws that kind of discourage butting off and creating new businesses, and because technology is built on other technologies, so you would think that if somebody thought that they could do better or create a better product, even if something else is the basis for that, that we would encourage that and continue to develop, especially in a business orientation. But at the same time, I understand protecting resources, and so it's a catch-22 kind of.
Yeah, John says it's a catch-22, and John makes a good point. It's ironic in a capitalist society that we would actually, that encourages free enterprise and encourages independence, that we would actually have a law that, or a situation that would say you can't go out there on your own, you can't use that knowledge, you can't better. Now, it may not necessarily be a law, but it's agreement. So let me argue this, John. Hey, I've got the right to tell you I'm not going to sign a covenant not to compete with you.
They have a right to not give you a job.
And they have, and as Tom says, they have the right not to give me a job. I mean, because the arguments for it are, well, you've got this right to bargain. Remember, we talked about that. Employees don't frequently have the right to bargain. And here's what the court cases say. The court cases out there say, hey, we don't like these restrictive covenants because what you just said, John, in a capitalistic society, in a free enterprise society, we don't want to stifle competition and free enterprise, all right? And so we don't like them. And when they finish and then when courts say, now, we don't like them, they always say, but we're going to enforce it, okay? And so they enforce them if there's a couple of things. First of all, in order to force one of these non-competition agreements, and you're all with me, right? I've lumped in non-disclosure, non-solicitation, and non-competition all together, okay? Talk about it in terms of non-competition. But when we put them all together, one thing that stands clear in most states is you have to have a protectable interest, okay? Now, what is a protectable interest? Somebody? John?
I guess anything that would result in a loss of profit or anything like that.
Okay. John says anything that results in a loss of profit, yeah, probably not going to let you off the hook that easy. Give me a little more specific. Well, let me do it this way. If I lost all of the names of a potential customer, if I lost all of the names of all of my potential customers, would that be something that could eventually lead to a loss of profit? And you say yes, and I think you're right, okay? So, if I go to the phone book and get all of the names of my potential customers, do you have a right to tell me that I can't compete with anybody in the phone book? And why not? You're right. You say no, and why?
Because it's public information.
It's public information, okay? So that's what I'm saying. It's not just the loss of profit, okay? One of the things is it has to be more private, if you will, okay? Or something that only you or very few people would know, okay? Some kind of special compilation of information, okay? Some kind of special compilation of information. Customers, potential customers, and it's debated, can in fact constitute a protectable interest, all right? But it has to be more than just names you got out of the phone book, okay? What else might make a protectable interest? Melissa?
I don't know, maybe like business plans,
Okay.
just management policies.
Yeah, business plans, along with that, policies, certainly trade secrets in terms of the recipes that we talked about and things of that nature, but also pricing, okay? If I know what, if I'm a copy, if I'm a copy salesman, all right, and I leave copy company ABC and go to copy company XYZ, and I know what their pricing is on their copiers, what can I do? How can I use that against them?
Undercut their price.
Undercut their prices. I know so-and-so will sell you this machine for X number of dollars, and I know what profit percentage they want. I'll cut it by 10 cents, okay? Or even $1 or whatever it may be, all right? So there has to be some kind of protectable interest, all right? Either special training, private information. Now, having used the phone book, information is not a protectable secret. Let me say this. If you go to great lengths to formulate certain information and compile it in such a way that you can do that in such a way that it becomes public information. Who read the Milfeld case in here? Anybody? Somebody? Remember, and it's not in your book, by the way. That was one of the ones I added. Okay, Jackie, kind of. That was a case that we had, and I'll never forget the guy. It was a great client. Called me up and said, "Hey, if I get crossways with my company, I don't want to be sued because I've got this restrictive covenant." And he says, "Are you telling me that if I get fired, that I'll be able to just go compete?" And I said, "No, you can't just." He said, "Because I'll just stop doing my job and let them fire me." And I said, "No, it doesn't work that way. You can't set them up." But long story short is, Milfeld it's a company here, transportation logistics company. They look at ways of saving companies freight information. And my guy used to be a salesperson with them, okay? A guy by the name of Bishop, I think, used to be their vice president. He left, started his own company, kind of like Jackie was talking about, and he ended up taking, or at one point, Roots ended up working for Bishop. So now you've got all of these people that were working for Milfeld now divided. So you've got Milfeld and then you got Bishop and Roots working. One of the things that came into play is my guy, and he never denied it, downloaded at the time he was leaving tons and tons and tons of information with regard to the names. Now, you want to know why he did it? Why did he do it? Any ideas?
So you could take it with him,
Yeah, but why did he want to take it with him? But why, Jackie?
so that he could turn around and.
No. See, he took it so that he wouldn't compete. You see, he had this covenant, right?
Right.
Yeah, that was kind of the reaction we got from the judge when we made that argument. No, our argument was, look, he took this information, and the reason he took it was so that he wouldn't compete, because he knew he had this covenant not to compete, and he didn't want to run afoul of that. So he took it so that he could cross-check and make sure. Now, I know, you all snicker, the judge snickered, I understand. But having said that, I can tell you and I'll get these facts wrong, so this is best of my recollection. But seriously, out of 11,000 names on there were only 5 or 6. And if those may be in the facts, I don't know if they are. But literally, there were only 10 companies out of 3,000 names or so. So there may have been an argument that he really took it, but nobody believed it, okay? And so what we did is, look, we'll stay away from all of these customers, all right? Well, they ended up suing us for millions and millions of dollars. And the court said, no, you're right, you have some interest. But one of the things that got addressed in that case was whether or not there's some protectable information in the way that they compiled their information. And it may have been. They took not only names, but then they went through these names and said, hey, if we take this factor here, the size of the company, and we take where the company's located and put all of that information together, all right, now we find who our best potential customers are. Is that a trade secret? Arguably it is. Is it knowledge what their names are, or can their names be obtained? Sure, that's public information. Where those companies live, is that public information? Yeah, sure. Is it information how big they are? Sure. All of those factors, what kind of business they do, but when they entered into a spreadsheet and divided all of that up and compiled it together, their argument was, hey, this is now worth millions and millions and millions of dollars. And I think, arguably, arguably they were right. It was a trade secret. Even though all of that information was public, it had been compiled, so it wasn't public. But the court says, hey, we're going to restrict it to the least restrictive means possible. It's an interesting case. Anything about trade secrets or covenants not to compete was in that case. Your book, I think, or the text or the supplementary material, talked about a case of Lamort versus Burns and Walters. You remember that case? By the way, Dave, let me pick on you again. What was the argument for why there shouldn't be a covenant not to compete in that case? What was Walters arguing? Do you remember?
Because he was an at-will.
Yeah, because he was an at-will employee, all right? And so we have him saying he's an at-will employee, and his attorney says, yeah, he's an at-will employee, so the covenant not to compete doesn't apply. Anybody, why not? Why make that argument? The judges disagreed. Court of Appeals, anyway, disagreed. But why make that argument that if you're an at-will employee, you don't have a covenant not to compete? And it's not, the text really doesn't. What could be the argument?
They
Lisa?
don't have a reason to fire you. They don't need to give you a reason why they fired you.
They don't have to give you a reason why they fired you, and you're free to leave at any time you want. So if you can leave anytime, they can get rid of you anytime, there shouldn't be a covenant not to compete, all right? The problem was he signed a document. So he had an agreement that said, I won't do it, okay? So now you're kind of taking that position, well, yeah, I'm an at-will employee. And then the courts say, look, whether you're an at-will employee or not, you've signed an agreement. So now we have a separate agreement over and above at-will status. Because if he had just been an at-will employee without signing the covenant not to compete, there wouldn't be any enforcement. But because he signed a separate agreement, he had to have it. Now, let's go back to weeks ago. Tough question. What do you have to have for a contract? Jackie, I think you were the one that gave me this, so let's go back to you. Remember?
Capacity, consideration.
The consideration, all right? No, consideration. So what was the consideration? What's the consideration in a covenant not to compete?
I mean, that's kind of hard to, I guess, say because it's like the company gets something out of it.
What does the employee get out of it? You come and work for me, and you've been working for me for a year, okay? And I say, Jackie, I want you to sign this covenant not to compete. What do you get out of it?
Like you're getting the benefit of like that work experience.
Okay, that's what I get as the employer, right?
Well, I mean, you're both kind of getting that because it's like the employer is getting your work experience or your work knowledge, but you're also gaining experience from being there and using their resources and the knowledge that you gain just from working around like their staff.
Okay, you gain knowledge.
It's kind of a stretch though.
Well, but then no, you're just working there. You still have a job. Because if you don't sign this covenant not to compete, what am I going to do?
You're not going to hire me. You're going to fire me.
Or I'm going to fire you. All right? Not going to work here anymore. But by signing it, hey, Jackie, you still have a job. Congratulations. Okay? And that's what most courts say, is that consideration, because that was a big argument, is these covenants not to compete, particularly after you've started, aren't valid contracts because you don't have an essential element, which is consideration, right? And courts are saying, no, you still get to work there. You now have something instead of just the employer getting it, okay? And so that's the nature of kind of this idea of consideration, if you will. And you don't, once you have a contract, it's separate and it takes the employment at will doctrine out of it, okay? Along with that, I think either the text or the supplementary material, Amanda, let me ask you, relied on, do you remember what else that court relied upon in there? What they used as authority? I think this was your question, but I'm not sure.
Oh, the restatement.
Yeah, the restatement, okay? And the restatement is somebody, and it may have been Amanda, it may have been somebody else. There were a couple questions on restatement. Restatement is not law, all right? But it's kind of authority, the people who are lawyers or whatever who in the past have written some law and said, this is what the law should be. Okay? This is kind of what the law should be. There were a couple of cases, the timing of my leaving, Lowther Johnson, I didn't have a lot of time. Well, there were a couple of cases I just couldn't wrap up, but I was in the middle of one that was really exciting in Illinois, where we had a guy who had been hurt in a horrible automobile accident. He was driving and there was a Corvette, or an owner of a Corvette. The owner of a Corvette his license had been suspended in 5 different states. And guess what it was suspended for? Yeah, Tom, drunk driving, okay? And so he goes to this dealership and he says, I want to buy a car. Now, this guy is, and admitted, he'll tell you, is an alcoholic and has been since he got out of the armed forces several years ago. And can't remember, I think his testimony was, I don't remember a day over the last 15 years that I've been sober. I mean, he clearly said, I'd go out, get a drink. He had a malpractice case, won some money, took that money, and went and bought a brand new Corvette. The next day after he buys the Corvette, he's driving it and kills a couple, their brand new unborn baby, and injures my people. Bad, horrible situation. And he had some insurance. But we went after, and I don't have apologies at all, we sued the dealership who sold him the car. All right? And the theory was, and the problem is, can you buy a car without a license? First of all, can you buy a car without a license? What do you think? Yeah, you ought to be able to buy a car without a license. And had that just been the case and they had just given him a car because he said, I want to buy a car, he could have bought a car. And I don't think we ever would have gone after MasterCars. But what we found out in that case was he, to the best of our ability, to the best of our recollection, was that they had asked him for a driver's license number. And all he had was a ticket. And this ticket showed that his license had been suspended. And so there's some restatement of law out there as to when you can sell a car, what you can do with a car, and we use that restatement to argue, wait a second, had they just sold him a car without asking for his driver's license, that's one thing. But if they sell him a car and they know that he's been suspended, then they have a duty. Because remember, torts are all about duty. Then they have a duty. Long story diversion, Amanda. Restatements are authorities that they're not law, but you say, look, people look at this, and here's the common sense argument that you should be able to make. Okay. Now, where that case goes, I don't know. We'll see, and it may eventually settle. But restatements are basically arguments made by other people, and it's in book form, and so the judges give it a little more weight than if just a lawyer says it. And that's kind of the idea with the restatement and the covenant not to compete there. Okay. Any particular question? When it comes to the only other thing I want to say, you've got to have a protectable interest. All right, in order to have a trade secret, or I'm sorry, a covenant not to compete, there has to be a protectable interest. All right, and then the covenant not to compete must be reasonable. All right, it must be reasonable. And it must be reasonable with regard to time. And what do I mean by time? Amanda?
Can't be for like 10 years.
Can't be for like 10 years. All right. And it must be reasonable with regard to scope. Bless you. Okay. So it has to be reasonable with regard to time. And it has to be reasonable with regard to scope. Well, what do I mean by scope?
Area.
area, okay? The geographical area, all right? So, for instance, was it in this morning's paper or yesterday's paper? Disc jockey around town, Woody P. Snow. I think maybe got terminated. I don't want to say that, but I think it got terminated. Contractual, as I recall reading it. And he had a covenant not to compete, okay? And his covenant not to compete probably, and they worked it out, I don't know what they did, but probably prohibited him from a certain area. If his covenant not to compete had said, you can't go work in the radio business as a disc jockey for the next 15 years, anywhere. Reasonable or not? Lisa, you're shaking your head no.
It's not reasonable.
Okay, and why not?
Because it's 15 years.
One, it's 15 years. Okay, what?
How
It's ridiculous.
Yeah, okay, it's ridiculous. And most courts would agree. It used to be that 5 years was pretty standard. We've seen courts narrowing it more and more, which kind of gets back to John's argument, this whole capitalist thing. Courts are now narrowing it to almost 1 to 3 years. We don't see very many beyond 3 years. 5 years, 20 years ago was still pretty common. 3 years it's now been narrowed down to 3, and really maybe even 1 or 2. Okay, Tom, what else?
It's unreasonable because that's his way of making a living. So
Yeah, but courts don't care about that. And when I say they don't care about that, that's not exactly true. They look at that factor, okay? And it may be unreasonable with regard to him making a living for the next 15 years.
Yeah,
From a time. So, but a time. Is it unreasonable to stop him from making a living for 1 year?
I mean, I guess you can argue that it's not really unreasonable because he can go find some other job for a year.
Right, and that's where the courts,
Yeah.
and that's how the courts look at it. So it's not just the idea that he can't make a living. But you're right, he can't make a living for 15 years. That's outrageous. But can we keep him from making a living for a year in this business? Sure, because he can go work somewhere
My
else,
argument was more than
arguably.
15 years than
Okay,
the year.
okay. Why else is it unreasonable, though? We say 200 miles.
That would basically make you move 200 miles away in order to find a job. It's more reasonable is like 25 or 50 miles
Okay.
as opposed to 200 miles.
Wholeheartedly agree. Why is 200 miles for, and let's take this couple of situations. Why is 200 miles unreasonable for a radio station here in Springfield, Missouri?
Because the radio station could possibly reach 200 miles. You don't necessarily know what their range or their signal strength is.
Okay. And really in this case, it doesn't reach more than 70 or 80 miles.
Yeah.
Okay. So you're right. At that point, it would be unreasonable. Are there some situations where 200 miles, and stay with you, Tom, are there some situations where 200 miles may be reasonable? Melissa says yes. Drew?
Yeah,
Okay.
like XM radio reaches like everywhere.
Okay. XM radio, depending on how big you are.
Yeah.
Okay. Outside the radio business. Let's get outside the radio business. Melissa?
Definitely. We have a friend that actually went through this. They had a company, they invented a product, and their employees had to sign a non-compete clause, and it was through the entire United States, because what their invention was could travel. 3 of those employees actually quit because they saw how much money they were making and went to another country and did it for 3 years. So 100% I think there should be.
Okay. Yeah, it just depends. You can actually have them worldwide. It just depends upon the nature. But when you look at these, here's the key. They got to be reasonable in terms of scope. They got to be reasonable in terms of time. And you have to have a protectable interest. Now, somebody asked me, hey, can you compete if you've signed one of these? Can you ever get out of it? Well, there are a couple times. If you've been fired without just cause, okay? So if you've been fired without just cause, somebody just terminates you. All right? They just don't like you anymore or whatever. In order to get an injunction, you have to do what we call clean hands. You have to come to court with clean hands. So you got to have a reason for the most part. And that's true even in an at-will situation. You go, wait a second, that defeats the at-will. Well, yes, it does. But the courts say we're not going to stop somebody from working if you just willy-nilly terminated them. You can do that, but we're not going to keep them from competing unless you had a good reason. Okay. The other thing is frequently you will see situations happen where they get in where somebody changes the compensation program. Okay. At the trial level, we didn't appeal it on the appellate level, but at the trial level in Millfeld, one of the arguments we were going to make is, or did make, is, or started to make, is they had changed his compensation agreement. They weren't paying him as much, so he was free, you know. As we developed the facts on that case, we decided not to go with that argument and just go, hey, we're not going to compete with anybody on this list, but to keep us from competing with everybody is outrageous, and to sue us for this amount of money is outrageous, okay? So certainly you have to, if somebody violates what they're paying you or tries to shorten their pay, okay? All right, any questions with regard to those particular issues on the restrictive covenants? All right, last, and let's finish it up here. The intellectual property, okay? And really, let me kind of give you the basis of the intellectual property. For the most part, intellectual property belongs, and we're talking about the creation of it, belongs to the person who creates it. Okay? If I write a song, that work belongs to me. Except in what situation?
You're assigned to like a record label.
Okay. If I'm basically what we call a work for hire. Lisa says if I'm assigned to a record label and they hire me and they say, we want you to create a song for us, all right, then that work may belong to somebody else. It's what we call work for hire, all right? Frequently, movie studios will find songwriters to write songs for their movies. You see that in Disney all the time, okay? Haven't seen those particular agreements, but certainly you could have a work for hire agreement where Disney hires Elton John for the sole purpose of what's the Disney movies that Elton John did? Lion King. Yeah, thanks. Okay. So I don't know what those agreements were. Probably a lot more complicated than we would talk about, but you could have what we call a work for hire. I hire you to create a specific project. I give you the funds for that project. Now, whose invention or creation, not invention, whose creation is that?
Be the company that hired the person to do the work.
Yeah, it's going to be the company that hired the person that does the work. Okay? Yeah, John?
Can there be like dual rights to something? For example, like if a musician was under a record label, could both individuals have rights to the song? Like the actual work could be the artist, and then the record company could have rights over the like individual track or something like that.
No, absolutely, absolutely. And you see that. I mean, those agreements get a lot more complicated. You can make those agreements however you want, okay? It's all about the contract. But generally, and here's the key. If you're in the employment field, you want to enter into agreements, into written agreements, so that there's no question as to who owns what, okay? So that there's no question. Because generally what you see in these disputes is that an employee invents something, all right, and then the employer wants it. Now, why does the employer say, hey, it's my creation, even though the employee invented it? Why does the employer say that? Why would they even have the gall to say that?
Perhaps because they use like their resources?
Yeah, he used their resources, okay? We hired you. You know, can you ask for more money if you've created something on the job? Sure, you can, but the employer's going to say, no, we pay you whatever we pay you, 8 to 5, to do your job, and you created it, and that's what we want you to do. Generally, if it is work created by an independent contractor, okay, it is not going to be the employer's or the hiring person's work, and that's generally, okay? In order to qualify as a work for hire under an independent contractor arrangement, 3 things must be found. The work must be specifically ordered or commissioned. The work must be specifically ordered or commissioned. Prior to commencement of the work, the parties must expressly agree to a signed document that it will be a work made for hire. And then third, the work has to be of a specific type. And I'm not going to give you all of the different types. I mean, translations, contributions to motion pictures, things like that. There's 9, 10 categories, and I don't care that you know about those 9 or 10 categories. The keys, and these are independent contractors, okay? Make sure we understand that. On the work for hire, in order for there to be a work for hire with an independent contractor, there has to be a written agreement. You can have a work for hire with an employer without a written agreement. Okay. Now, just real briefly, and we'll wrap up, and if you take any consolation in the fact that we've gone late tonight, hey, we're missing 2 hours next week for your test, okay? So feel excited about that. What was the case where this independent contractor, you're in your text, was that the community creative nonviolence? The independent contractor created a statute, remember, and there was a fight over whose work that was, okay? And in that case, there was an agreement that they had fought over that work prior. And there were some agreements, and the independent contractor could show that that the artist was an independent contractor and not an employee, okay, not a particular employee, with regard to the fact that there was no particular written contract, okay. The other one that came into play, there was another one either in your text or in the supplementary, I don't know, I can't say that word, supplement material regarding the comic book. Remember the comic book stuff? What was the name of that? Was that the Marvel or?
Simon v. Marvel.
Okay. You had Simon v. Marvel. You also have, there's one in 2011, which I don't know that I gave you, was the Kirby, Marvel v. Kirby, which is another case. Similar cases. So you get a lot of these out of these comic books because when these guys invent these or create these comic books, what do they get paid when they're young, 22-year-old, 18-year-old, and sell to some company like Marvel? You give them $5,000, $10,000 for their comic book invention, and they think, wow, we've made a lot of money, and yet 10 years later they realize, they gave a lot of money away. Was it Simon? Is that what you said, Jackie? In the Simon case, they actually signed an agreement, a settlement agreement, that said this is a work for hire, okay? But the court allowed the creator to win that case. Why?
Something about a right to terminate?
Yeah, a right to terminate, which is really a pretty cool, anybody like have in their family somebody who's written this great work or some wonderful song? Because here's what right to terminate basically is. The right to terminate says, okay, for you guys who created these Superman comics after a night at the bar or whatever, and then sold it for $3,000 or $4,000, okay? And now you saw the company make millions and millions of dollars. We're going to protect you. And because of your foolishness, if you'll go ahead, you will have a right. You can have a right to terminate that after 28 years, after 56 years, all right? And that right not only applies to the author, it may apply to the author's immediate family, okay? So if I created Superman and I want to come back 56 years later and say, hey, I created Superman, you've been living off Superman for a long time, I want to claim it back. The copyright law actually allows me to do that. Okay? So that's what that right to terminate is. I can go and say, I'm terminating despite what agreements we've had since then, I'm terminating your right to use it. Now, this right to terminate. Everybody understand what the right to terminate is? Real simple. Yeah, Jackie?
Is it only after certain time increments, or is it?
Only after a certain period of time.
Okay.
Yeah. Only after we're talking years.
Right.
We're talking a serious period of time. So everybody understands the right to terminate. Okay? Understand this as well. The right to terminate does not apply to a work for hire agreement that was signed before the work was commenced. Here's what happened in the Simon case, and it's a little tricky. In the Simon case, they didn't have a work for hire at the very beginning. He created the comic book. I don't even remember what the comic book was. Anybody remember what it was in Simon? It may not have gone there. It may not have gone there as to what it was. Because most of these termination, right to terminate cases involve comic books, or a large number of them do. But whatever the comic book creation was, they entered into a settlement where the creator admitted or said, this is a work for hire agreement. Okay? And he says that in the settlement agreement. So how is it that he has the right to terminate? He says this is a work for hire in the settlement agreement. Then he comes back years later and sues under this right to terminate. How does he win? How does the creator win? Here's the key. That settlement agreement where he said it was a work for hire was done after the work was created. Okay? If you enter into a work for hire before doing the work, creating the work, that right to terminate doesn't apply. If you enter into an agreement after you've created the work, then you have the right to terminate. And in this case, it's really clear because he had admitted in a prior agreement that it was a right to hire. And the court said, we don't care. Because the language says, here's what the language says on the right to terminate. Notwithstanding any agreement to the contrary. We don't care what else has happened. You have the right to terminate. Okay? Does that make sense? The key thing to remember is not so much in this right to terminate, although that's really an interesting concept. Because seriously, if you know somebody, if you're a member of an immediate family who's created this great, wonderful project, you can terminate that, even as a family member. Okay? But the key here is to understand how it applies in the work relationship, where are you a work for hire? Who owns the creation? Regardless of whether it's a piece of music, a statute, whatever it may be.